welcome and distinguished guests to the second day of the 16th Global IP Convention. Yesterday we delved into the fascinating interplay between IP and sustainability, explored the latest legal updates in Turkey and grappled with the ethical and practical consideration of deepfakes. Today the journey continues. Prepare yourself for an enriching program brimming with diverse topics. With our first session titled IP Risk Measurements and Mitigation, Sharpen Your Competitive Edge and Safeguard Your Clients' Innovations. This panel will be moderated by Dr. Shadra Damle, an in-house IP consul at GIPC, a leading gaming and entertainment company based in India. Dr. Shadra is currently leading the IP practice and managing their global IP portfolio in gaming, esports and music. With over 15 years in the field of IPR, she is adapting patents, copyrights, trademarks, and industrial design laws, and also serves as co-chair for the Indian IP Alliance's Education Committee. Our first speaker joining Mrs. Damle in this session is Mrs. Begüm Ertürk, the legal manager at Sabanci Holding. Turkey's leading conglomerate, engaged in a wide variety of business activities through its subsidiaries. Mrs. Begüm is a lawyer and trademark attorney with over 12 years of experience in IP and IT law, data protection, and cybersecurity. She has worked with top global firms, provided training courses, and led companies projects for multinational companies. Our second speaker joining this session is Dr. Stefan Walke, the CEO at ThyssenKrupp Intellectual Property GmbH. He studied physics, philosophy, and macroeconomics at Bonn University. He began his career at McKinsey, later worked at Bayer and Danaher, and joined ThyssenKrupp in 2011. He is 47 and has 3 sons.
So good morning. I guess there are still people outside, but we can start. So today we have a panel discussion on IP risk measurements and mitigation. So as she has already introduced 2 speakers, so what we have decided the flow will be, Begüm will be covering more on the trademark aspects, Dr. Stephen will be covering on patents aspect, and I myself will be covering more on the copyrights and industrial designs. Now we all know that IP risk, is not necessarily has to be from competitor. It can be due to non-compliances of certain legal mandate also. So we'll start with Begüm, and I would appreciate if anyone from the audience would like to add any point or share their experiences during their professional practice, any IP risk management they identified and how they have overcome. So we'll be happy, the session is interactive, so we all learn from each other's experiences. So you can start with the presentation.
Thank you for introducing me, and thank you very much for Global IP Convention for having me today, and thank you coming and spending time for us to listen us, and you will also, of course, add your experience and add your insights to our presentation and make this panel more valuable. Thank you for you as well. So I start. My topic of today is IP risk measurement and mitigation. As Anchor introduced me, I am the legal manager of Sabanci Holding. So I am focusing on IP and IT law. That's why today I will be talking about, especially from the trademark aspect, IP risk measurement and mitigation. So, why IP risk measurement and mitigation is so important? We have to ask lots of questions to measure and mitigate our IP. So I have a little bit prepared 5W and 1HR. We need to discover and ask ourselves why IP measurement and mitigation is so important. What types of IP do I need to protect Let's start with what is so important actually, why it's so important to measure. Can we measure our IP risk if it's possible? Actually, according to my opinion, we cannot measure 100%, of course, our IP risk, but depending on some assumptions, we can measure it and we can, of course, find financial impact as well. So why IP risk measurement is so important? Because our IP, the IP of our company is so important. It's the lifeblood. Because it reflects the value of our company. It presents the brand of our company, because when your company provides some services, it is known with its trademark, with its IP rights. So that's why you need to protect and you need to design according to the IP law, of course. Actually, IP is so important because it also help your company's valuation. When you, for example, sell your company, the buyer is focusing on your IP rights. So you need to find your IP in your company. You need to measure your risk if your IP rights are compliant with law, if your IP rights are very well discovered and also protected in a digital form or in a physical form. You need to discover actually your IP, because we realized in our group of companies that, for example, some copyrights cannot be considered, some projects cannot be considered as copyrights, but they have also some value, they have also some added value to our company. So you need to focus and you need to get some help, get some legal advice from your law firm. So where to monitor to find your IP infringements, then you need to really question about it before actually start to measure your IP risk. So I can talk about my company and my group. Actually, Sabanci Holding and its affiliates operate in 14 countries and performing mainly in 7 sectors, such as banking and finance, technology, energy. Since Sabanci Group has more than 1,353 IPRs registered in the world, we have a huge risk and at the same time huge workloads to manage it, to mitigate it. So we have 620 trademarks, and among 820 trademarks, we have 430 trademarks only registered abroad with foreigner companies. But not to be tricky, of course, when we count our IPRs, we start with the first registration of our IP rights. For example, this 1,353 trademarks means first registration, because you know the family of IPRs. So, for example, you register in Turkey for A IPR, but also you can register this A patent, for example, in Germany. So you cannot say that we have 2 patents, for example. You have 1 patent, but registered in 2 countries. So not to be tricky, we have only counted our first trademarks. First IPRs actually. So it covers patents, industrial design, utility models, copyrights, and as well trademarks as well. So Sabanci Group's IPR and third parties IP risk measurements, how to do it actually. We need to identify all IP assets. So we need to focus and discover what we have at hand. We have trademarks, patents, utility models, copyrights, what we have. We need to identify and then assess the strength, assess them if they are compliant with the applicable law, because they are registered in the different world, the different countries. So different countries has its own legal system, of course, so you need to protect them in compliance with the applicable law. So also we need to monitor the competitiveness of the market before, for example, designing our trademark. So we need to measure the risk of the markets. So when we launch a new before launching a new trademark, of course, we need to monitor the competitiveness of the markets. We need to also monitor and detect unauthorized use of our IP. For this, we need to use some digital tools because in the digital area, of course, we have lots of more risk than before than compared to the physical world. Because sometimes in the physical world, you can know where to find it, but in the digital area, you cannot really know where to search and where to find it. It can be also sold in dark web. It can be sold or pop up in a metaverse world. So you cannot really track and trace your IPR. So you need to focus almost all aspects. So you need to find a good service provider to track and trace all of this digital area actually. So we have, for example, a partner. They can search for our trademarks. If, for example, in Instagram, Sabanci or SA trademark are used, they can track in social media, they can track in Telegram, for example. They can also track in dark web. Dark web is very important. Since we are a family, we have actually based family company. So we have Sabanci names a very well-known trademark, but at the same time, the name of the family members. And family members are in the board, so their name is also their trademark. So we also check dark webs to check if a fake, for example, email address or fake information or true information of them are sold or are shared or are released in dark web. It's very important in the digital era. So we also as I mentioned, we are in a conglomerate, so we have lots of subsidiaries, but most of our subsidiaries is a GB format. So we need to also work very hard with our shareholders. So shareholders also should pay attention to how to use our trademarks, GB's trademarks. So how we can reduce this IP risk? Actually, so as you very well know, IP risk, when you try to mitigate, you can avoid the risk, you can transfer the risk, you can reduce the risk, or you just need to accept when you cannot find any other solution, or when you assess that the financial impact is not that much important. So you accept this risk. Maybe this risk is just too low, or just not valuable to make that much effort, so you accept it. So we need to start, when we mitigate our IP risk, we start by creating a strong brand strategy. Our brand strategy actually is very old strategy. We still follow this strategy since 1925 actually, since 1925 we follow this strong brand strategy. As you may know, we have two main trademarks, Sabanci with bubble and SA with bubble, and also we need to protect our SA as a well-known trademark. All of these three trademarks are very well-known trademarks. Why they could become very well-known? First because our holding story is very old, so as you say, 1925. But the second one is because of our strategy, because we put our Sabanci and Sa we create when we built a GV when we established a new company. We put this SI with bubbles or Sabanci with SI with bubbles. With our as a corporate brands. So with our subsidiaries actually, we can spread our trademarks everywhere in 40 countries, or even with our foreign GV partners. Because our GV partners can be Carrefour, Bridgestone, and E.ON. E.ON is the shareholder of Enerjisa. So they can also, as our foreign partners, they can also spread our trademarks everywhere in the world together. That's why we can become, our trademarks can become very well known all around the world and easy to register actually. So this is our strategy, and also this is another strategy, of course, from the Akbank side, from our banking and finance subsidiary side. And with Akbank, we also use a key for example, insurance company. So first of all, you need to create a strong brand strategy, and you need to have a story actually. If you don't have a story, you cannot explain your trademark, you cannot build your service or products based on this story. If you don't care about your trademark strategy or story, after a while you can be, you must be ready to be lost or not known actually. So we can also build an IPR governance, which means you need to create policies and procedures and many other kind of course, corporate documents, and you need to make them applicable. Of course, you need to register your trademarks and renew them, and if they are not used, you need to remove them. We also use a digital IP management platform. We have actually built it and created by ourselves in order to manage and see what we have at hand as a Sabanci group, and mitigate if there are some risks. So we can see the big picture on that platform, all IPR of the Sabanci group of companies. So we can check and we can warn our subsidiaries if there is something, there is some error, or there is if we can advise them to make their IPR more valuable, etc. So we can easily check all of our IPRs through this digital IP management platform. So, of course, we need to prepare strong contract clauses. Contract clauses, when we say contract clauses, you can understand easily license agreements. And at the same time, when you manage an M&A transaction, you have also share purchase agreements and shareholder agreements. So you need to also protect your trademarks or the seller's trademark. So if there is something, if there are some risks and you cannot measure during the DD process, you need to design and create a very strong contract clause for this SPA. You need to put this risk in the specific indemnity clauses, for example. And of course, you need to protect your IPRs with new technology. For example, for copyrights, from the copyright perspective, you can use blockchain-based systems. And of course, you can use another type of quantum technology-based protector tools. So all I can say for now is this, and I am open to your questions to enrich more my presentation. Thank you very much. And if you want to agree, you can expand the class. Thank you.
Is there any questions from audience? Since she was mentioning about trademarks and further additions, because trademark is only IP which is perpetual. No other IPs like patents, designs, and copyrights all have a certain shelf life. You cannot extend after that. So trademark is only the IP which can stay with you for the perpetual, provided you renew with time. So as you rightly mentioned, every trademark should have a story. And you have to evolve as per the market trends, otherwise you are out of the market. There are many brands we know that because they have not evolved with the time and not identified the correct measures, they are redundant, like they are no more in market. And another point with regard to risk mitigation I would like to share from my experience. Now since I come from India, now in India we have a lot of diversity. So we have to do filings in regional languages also. So if anytime your client wish to file in India, and depending upon the line of business, we suggest to file trademark in the regional language also. Why? Because now India has a lot of diversified areas, and each area has a different population from economic and educational background. Not necessarily they can identify your brand in English. Now for this example I'm giving, we have a brand called Global Music Junction. So it's a famous channel on YouTube, you can just find it out. So what we have done for this is that we have registered this trademark, Global Music Junction, in almost 10 to 15 regional languages in India. So like if you know geography, like in Haryanvi language, because this portion also goes to Nepal, Bangladesh, Pakistan. So we have registered all these trademarks in those regional languages also, because you never know the intensity. Because see, enforcement and risk can possible only when it's an ownership. So you can enforce your rights only when you have a valid IP rights with you. And whenever you want to enforce, registration plays a very important role. So this is the one point that I would like to mention. Another is that now recently, since you mentioned about metaverse, now there are certain applications and we are including the word metaverse in our trademark description. So I come mostly from the gaming background, esports. So the future is metaverse. So nowadays, so whenever you are filing, be futuristic when you are filing your applications and try and include the words and terms in the classification which will be covering future line of business also. And I guess there are certain brands like this Nike, and I don't remember the another example, it is from the food industry. They have already started registering trademarks. So it's not that we have to file in metaverse, it is that you have to file an application mentioning the specific words that in case of future infringement in metaverse, you have certain rights to enforce. Okay, so this is a few points that I wanted to mention, and also trademark more services helps a lot. Even we do follow that, because we have a portfolio of almost 500 to 600 trademarks, mostly in India and few outside India. But yes, trademark watch services is very important if you are like having global presence and you have multiple diversified businesses. Trademark watch services where you can actually track the third party marks which are similar or conflicting to yourself. So at least at inception level, if you identify the risk, it can be minimized and can be controlled. So now after discussing trademarks, I guess I request Dr. Stephen to share these points on patents.
Yeah, yeah, thank you. Now we need to find the other presentation. Yeah, it's only 2 slides. The first one will be about the first one will be introducing to the book and how IP is managed, and the second one will be about risk management. So don't worry. But these are complex slides. That's the first one. Yeah, the first slide is about what does the book mean. So we are talking about some complexity. That means something like 400 group companies worldwide, currently 100,000 employees, something like 30 billion euro revenues, being active in steel producing. Yeah, that means that's where we are coming from. Second largest European steel producer. But also automotive industry, so we are producing shock absorbers, steel columns, and springs and stabilizers, and all that stuff. We are in industrial plants, that means chemical plants. We have cement, we are producing cement plants, or engineering cement plants. Also the large bearings for wind turbines, for example, but also hydrolysis plants for producing hydrogen. Yeah, we also have a material trading business, that means ensuring the supply chains for materials, for metals, for plastics, especially also for the airline industry. and finally, we are also building submarines or surface vessels. Yeah? So we understand some complexity, a lot of inventions, a lot of technologies, and all these inventions need to be secured. And when I started that 12 years ago, we had no idea how many patents we have. We had far less patents than competitors, and we didn't have any patent lawyers. Well, we had 2 patent lawyers in the 7th level of the legal organization, and nobody found them. And then I asked myself, well, what is the task of an IP department? And the first task is to effectively protect our group companies from IP issues. Yeah? That means effectively protect them so that they are able to invent things, produce things, and sell things without being disturbed. So that's the effectiveness dimension. And, but the other task of an IP department is to do that efficiently. That means to get as much as IP as possible for as less money as possible. And when I'm talking about IP, it's always patents and trademarks. So today we are talking about something like nearly 20,000 patents, 10,000 trademarks for a lot of company names, but also a lot of products. So that's all the same. This task goes a bit down on the effectiveness side. First of all, we needed to talk about who is owning the IP. So we have a differentiated ownership, which is differentiated between economic ownership, which is always a business unit, but also a second declaratory owner, which is always a ThyssenKrupp AG or our mother company. And out of that declaratory ownership, we could do everything. We could file a patent, go to court, claim for damages and everything, give you a license. But on the other hand, we avoid any tax risks. That means the economic ownership always stays with the owner who has the patent, invented it, uses it, and so on. So the second line is about, we were deeply convinced that we have a lot of brilliant engineers worldwide, something like 5,000 engineers, but nobody asked them for patents. And therefore we traveled around in the beginning and now have available a lot of formats in order to work with people on creating IP. Yeah? So these are harvesting workshops, simply listen to people and ask them. That's TRIPS methodology, which we now support by AI, for example. That's key buying factor workshops or service workshops or specific AI invention workshops and so on. Yeah. Then we have a global inventor incentive, we have a flat rate remuneration system, and all that stuff simply to stimulate IP and to harvest it. The third thing is to give that IP some direction. That means I went to all R&D heads and always asked them, please give me a technology tree, which is a complete set of their technologies. And then I wrote behind that, what IP do we have, what IP do other people have, do we have too less, and let's decide on IP focus area. 2 or 3 areas where you really want to develop IP, but not 10 areas, but also not 0. Yeah? And we also put that for discussion. That means annually I talk with every CEO of every group company and ask them what needs to be changed. Yeah? Do we need a new IP focus? Can we switch off an old one? What are your competitors doing? Are you filing enough? Do you get enough inventions? Do you observe competitors? What is happening? Yeah? So it's very important that top management is really involved in thinking about IP. And the last line in effectiveness is understanding our IP environment. So we have a large system now where we observe all competitor IP. We lay the basis for objections. Based on a lot of filters and a lot of engineers helping us to observe what competitors are doing. Well, now it's gone. Okay. And then we also use that competitor observation system for finding the basis for later FTO softwares. Well, if that's about the effectiveness of an IP shield, and within the recent years something happened. Yeah? So we started 10 years ago with below 300 first filings, so we went up nearly to 700. Then we sold our elevator division, our mining division. We also had reduced R&D budgets due to Corona. So we went a bit down, but on the other hand, now we are just ramping up from below 300 to now much more than 400, I'm expecting. So on the efficiency side, the most important thing was that the businesses decide about IP. So at the beginning it was much too dangerous for me, together with my 2 patent lawyers, to decide about IP. Therefore, I asked all businesses to form operative patent council. They always have the head of R&D, the head of marketing and sales. They sit together every two or 3 months for 2 hours. And the head of R&D will say, I want to have all these inventions of the recent 2 months being filed as a patent. And the head of marketing and sales will say, well, I want to have that in the following whatever countries. Yeah? But the meeting takes place in Excel, not in PowerPoint. And there is a nasty figure on the bottom hand right side, which is getting higher and higher. Yeah? And these are the full costs of their decisions. And then they get a bit nervous, and the head of R&D says, well, I have an IP focus, I don't want to file everything, all technologies. And the head of marketing and sales will say, well, we will never build a cocoa-ree in Venezuela, and therefore we don't need cocoa-ree patents in Venezuela, yeah? Or submarine patents in whatever. And so they both take a careful decision based on full costs, what they want to have. And then it's a decision of me as an IP department how to create that IP coverage. It means doing that with external patent lawyers or with our internal patent lawyers. And from year to year, I promise them that the price for creating IP will get lower and lower. Yeah, and with that mechanisms, I hired a lot of patent lawyers, basically 50 patent lawyers in the recent years, in order to do that in-house instead of externally. So then, after doing that for a while, we found out there are not only patents but also trademarks. That's what I said. That means we found out that we have 10,000 trademarks which we need to manage as well, also with the same mechanism where the business unit needs to decide what they want to have. And then we file all the trademarks. We will also do that for our central company sign, the ThyssenKrupp name and trademark and picture and the claim. And by doing that, we do that much cheaper in-house than we did that before. Externally, we hired a trademark team, trademark lawyers. Well, then we also have an external community of people in the businesses. And that means we call them IP coordinators. They are sitting within the businesses, they are helping all inventors, but they are also preparing the decision for the operative patent council. And yeah, so they are an important community within ThyssenKrupp, but they are outside my organization. Well, and then we as a team need to manage the mix between internal and external. That means our own patent lawyers and insourcing, and trademark lawyers and insourcing, but also doing that with external IP law firms, where we currently are massively ramping up using external IP law firms since we are not able to manage all the increasing volume. Yeah, and finally, we also went back to all the industry associations, for example, the German Association of Automotive Builders, the VDA, the German Association of Machinery Builders, which is the VDMA, where I'm heading the sub-team, also to the VDI, which is the German Association of Industry Associations. So it's simply trying to be a good citizen within all these IP groups within the German, or let's call it European communities. Well, and that's how IP is managed within ThyssenKrupp, and I could talk endlessly about that. Yeah? Also about how we currently use AI, how we protect what our businesses are doing in AI. That's always the effectiveness stream, but on the other hand, how we use AI as an IP department. So that would be on the efficiency side. But that's another talk. So what's about risk in that now? Now we need to go to the next page. But let me explain what is on that page. Yeah, very good. No, when I started that thinking about IP within ThyssenKrupp, after 1 or 2 years, I woke up in the night and thought, well, if my CEO would ask me what is the risk position of IP within ThyssenKrupp, I wouldn't have an answer. And then I thought, well, in order to give a structured answer, basically there are 4 different types of risk. The first, very basic risk is of having not enough IP. Yeah? At that point in time, I discussed with a lot of business units, and if a business unit tells me I have 10 times less IP than all my competitors in the world, it's a risk in itself. Yeah? You have to have enough IP in order to, well, if someone sues you, you tell them, well, I have so much IP and you have so much IP. Yeah? So my stack of IP is much higher. So for sure, I prefer to find something where you infringe my IP. So think about whether you sue me or not. Yeah? You have to have some substance. That's the first thing. The second is you need to have substance for cross-licensing. Yeah? Otherwise, you can't bring anything to the party. Yeah? So these are 2 good reasons why we have simply to have enough IP. Yeah? And therefore, That's the first basic IP risk. The second one is to infringe other people's IP. Yeah? If we find that too late, then we need to develop around as costly, or the other risk is that people stop our production and so on. Yeah? Or we have unexpected high license payments. The third risk is that we have IP in contracts, formulated in the wrong way. Yeah? So I would like to know whether we have IP in all contracts with a complete external world. That could be suppliers, employees, customers, cooperation partners, whoever. But with whoever we do external business and have external contracts, then we would like to have IP clauses in these contracts and the right IP clauses. Yeah? And the third one, the last one, is to use our trade secrets. So it's not only using them, yeah, but if we use trade secrets, then we would like to find out. And second, then we will also to be able to document that we like to protect our trade secrets, and then we will be able to go to court in order to show that we would like to keep our trade secrets, and finally we would like to win the process at court. Yeah. So it's several goals within trade secrets. Finally, we don't want to lose them, and we would like to win court proceedings. So the next thing is talking about risk is fine, yeah, but now we need to measure it. Yeah. Given my education as a physicist, I always need a figure. And for the first one, it's very easy. Yeah. I compare just the IP we have in a certain area of technology to the top 3 competitors in that industry. And then if my business unit has less than 20% of the top 3 average, yeah, then they get a red line. And if they have 20 to 70%, they get a yellow line. And if they have more than 70%, everything is green, that's fine. For infringement, it's a bit more difficult to measure. I ask what percentage of your revenues went through an FTO analysis with my people. Yeah? And if it's above 70%, that's fine. If it's 20 to 70, yellow. And if it's below 20%, well, that's a bit dangerous. Yeah? Finally, we don't know, or we didn't approve that you have freedom to operate. For IP in contracts, it's even more difficult to get a quantitative feeling. I asked my contract lawyers, did you see all contracts of that business unit? And are there IP clauses involved? And are there the right IP clauses? Yeah? So it's a bit of a feeling. Yeah? If you don't see a contract, normally you don't know whether you've seen it or not. Yeah? So it's a bit of a feeling. Yeah? Do we see all contracts of that business unit, yes or no? Yeah? And it's a more difficult figure. And the last one, trade secrets, I just would like to know whether they have the structures. The structure is a trade secret officer being named and responsible and communicated. The second one is are all measures identified and all secrets classified across the value chain. And the third one is are they implemented. That's probably the most big figure of all, but also normally we have a view on a business unit whether they keep their trade secrets or not. Yeah.
This study based on some empirical study, it's less than 20% or based on some empirical study by your organization.
Yes, exactly.
By some case study by your own organization, level of risk.
The level of this? Well, it's as you can imagine, these are red, yellow, and green lights for 25 business units, so it's a complete complex picture. Yeah. And hopefully it gets better from year to year. Yeah. But more interesting is to get awareness for that, and therefore I have 3 mechanisms here. First of all, I'm talking about that specific line of risk with all CEOs in their annual IP dialogue. Yeah? So I will tell them, well, now for trade secrets you get a yellow, and for substance you get a red or whatever. Yeah? The second is controlling. So as every large company, we have a controlling department, and they are sending out a risk questionnaire of 200 questions every half year, and they need to make a mark if you have a fire insurance or whatever. Yeah? But within that questionnaire, you also have 4 IP questions always, yeah? And you have to mark within these 4 categories whether you think you are secure or not, yeah? Or whether you have mitigated these risks. And the third instance is our audit. Yeah? A lot of large companies like yours will also have an auditing team. Yeah? That's a bunch of people who are traveling around, and they are checking all group companies from time to time, always 10 per year or so, yeah? Whether they are behaving well. Yeah? And together with audit, we wrote an IP audit guide. Yeah? And within that audit guide, now the audit people could look whether a specific company with an interested group is behaving according to the rules regarding IP risks. Yeah? And the audit guide all the people were proud that they now have a different topic to be analyzed than the 50 years before. Yeah? So what I'm saying is, first of all, you have to think about which risks you have, then you have to quantify them, and then you have to find friends in the company, which is CEOs, controlling, and the audit team, in order to help you to mitigate that risks. Good.
So thank you, Dr. Stephen, for those inputs. Now I guess from these two panel discussions we have understood there is no one standard that can fit all the industry. Okay? You have to prepare your own checklist depending upon the client you are serving. Just 2 points that I would like to add and then we can conclude this is about few experiences that I would like to share about the copyrights and in the design experiences. So I remember when I was working in a law firm, we had filed a design applications. These designs were filed by the applicant, the industry themselves. But then they identified the industry's designs were copied by the competitor. And then when we wanted to enforce our right for the infringement, we came to know that the designs which were protected in form of registrations were different. And the designs which went to the market were different. There was slight difference. Now because of this difference, we were not able to enforce our rights. Okay? It would have been really good if the client would approach us like on time during the registration process itself, because in IP, at least in industrial design, it is about the looks itself. So if the design what you are filing should be the design exactly what is going to the market. If there is slight changes in the design which is there in the market, to enforce the right, it becomes very, very difficult. Rather you cannot enforce your right. With the design, there is a difference in the registration. Second, since you mentioned about the agreement clauses, now I mentioned that in esports, okay, when we are conducting the competitions, okay, these competitions are global competitions. We get part like teams and participation from various countries. Now during this, it is our IP format of conducting game, but we do collaborate with multiple stakeholders. So in this protecting our IP rights, it also becomes very important to have a good tight contracts in this case, wherein we protect our rights. So sponsorship and advertisement, third party advertisement, so all these are to be protected with proper agreements. So in agreements, basically jurisdiction, since you are not operating only in one territory, you are going global. So royalty sharing, ownership of IP and jurisdiction is very important that you should actually look in during the contracts. And the last thing which I would like to share about the copyright registration. Now in copyright we faced very funny situation. We have a blockbuster song in India. Now this song was copied by multiple parties across the globe. So for that we wanted to enforce our rights. So when we write to YouTube, okay, to take down for the takedown action, they ask for some registrations. Okay, now there is an exception in the copyright because at least in copyright creation we were able to show our ownership even without registration. So after repeated follow-up, they took down the action, like the particular IPs were removed from the sites. But when it comes to trademark, okay, the takedown action becomes very difficult because YouTube either act only on your IP registrations or with the court orders. So only the copyright is exception when you want to enforce your right with any YouTube or digital platforms, but at least for the trademark infringement, registration is only the options and those are territorial. So we are actually figuring out, because our products go across the globe and on the web it becomes very difficult to identify which is your best territory. And it's practically impossible to file your trademarks in all the countries. So in that cases, at least you should cover the major countries in which you are doing more business. Of course, you have figures with you, and depending on it, it is recommended that the filing should be there in those countries. Because if you are online service industry and you want to enforce your right in future for any infringement, registration certificate is the conclusive proof which you can actually show to the platforms and take some valid action for the infringement even without going to the court. Now with this note, I guess we can conclude with our panel and we'll be happy to take any questions. Or if anyone wants to share the risk they identified and the measures taken by them. Anyone from the audience?
I think I can share one. I
speak quite well.
Hi, my name is Marcel. I'm from Baseline Group, another colleague from automotive sector. We had a situation that actually happened in Africa that combined the patent infringement with the copyright, with our branding. We actually were notified by another company that owned a patent, and they notified us about an infringement. But thank God, we actually find out that we were not infringing the patent. Someone who actually copied our box infringed the patent and were selling with our brand. If I'm not wrong, was in, I want to say Egypt, but I'm not sure. And then we needed to do two different ways. We needed to negotiate, and then still going on, of course. And I want to know, what do you suggest us to do? Because we tried to negotiate, and the owner of the patent said, it is your box. And we cannot find who is actually copying the box. So right now we are in a bit of a pickle, I can say.
Well, interesting and complex, yeah. Actually, I don't have an immediate answer, but in that case we need to careful investigation, what is possible, especially in one country. Yeah? First of all, what we have, and then what is possible in which country. Yeah? Yes.
I can also share an experience that I learned in another conference actually, because I don't know if you put QR codes which cannot be copied on your box. So this box cannot be copied and also identify that it's not your box, even though you cannot find the person.
The situation now is the owner of the patent. The owner of the patent is actually, here the lawyer already told us, I don't care if it's not your box, it is with your brand.
Yeah.
So this is
that's why next to your brand you need to put a QR.
Yes, and actually what you suggested, I was going to add the same point, because there are certain counterfeiting measures that you can have to take, because it's basically we have to learn from our experiences. This you have encountered in Egypt, maybe you encountered in some other jurisdiction as well. So as a measure, like since I've been also worked on the pharma side earlier in my career, so there are in pharma industry, so you can apply the same analogy. In pharma industry, if you see medicines, okay, in medicines they follow, they have holograms and they have specific packaging. Okay, where there are the strips, there are holograms, and various different technologies are available which is unique to your product and which can be duplicated but with great efforts, not easily. So if in this case you have to prove that the product which is counterfeit and it's not the original. If it is not original, onus is of course is not on you, because you are liable if it is owned by you. But if there is sufficient due diligence, see after all, and there are certain brands which have the local managers or the, what you can say, in some brands there are brand managers who actually go in the market. I know this for Mercedes. My friend has been working, so they actually go in the local market, check for the counterfeits and take the remedies, and they learn from their experiences what are the measures that are to be taken to prevent counterfeiting. See, counterfeiting cannot be eradicated, it's not so easy, but at least it can be minimized. So I guess QR code or some kinds of holograms that are suitable. So if they are corrugated boxes, because it is huge and some engineering product is there, then corrugated boxes or whatever packaging material you are using, you should look for the good counterfeit technology, stickers or whatever suits your product, and have some due diligence back end. Thank you.
Are there any other questions? A round of applause for our esteemed panelists. They are equipped with us to fortify our IP defenses. We explored the captivating world of IP risk management, learning how to identify and vanquish threats to our precious patents, trademarks, and trade secrets.